Okay, Yusufel here again, back with another case. I had to come back and read Shapiro versus Thompson. And I got to reread a lot of cases, but a lot of people like to reference this case. You know, in the last video, a lot of people were referencing this case. And this case is worse than the last one. Listen, I don't know. Listen, after this, you people better start reading these cases instead of throwing around these citations of authority, not knowing what you're talking about, especially if you're going to be trying to use them in court. You look ridiculous. This is Shapiro versus Thompson, volume 394, U.S. Reporter, page 618, year 1969. They claim that this is a right to travel case, that this proves that you have a right to travel. This case has absolutely nothing to do with right to travel in the sense of using an automobile or license requirements or anything like that. This is a welfare case about traveling from state to state, because that's what travel means, to go from state to state, and whether or not a person can go to a state as a welfare recipient. Let's look at this real quick. These appeals are from decisions of 3-judge district courts holding unconstitutional Connecticut, Pennsylvania, or District of Columbia statutory provisions which deny welfare assistance to persons who are residents and meet all other eligibility requirements, except that they have not resided within the jurisdiction for at least a year immediately preceding their application for assistance. Appellee's main contention on re-arguments is that the prohibition of benefits to residents of less than 1 year creates a classification which constitutes an invidious discrimination, denying them equal protection of the laws. Appellates argue that the waiting period is needed to preserve the fiscal integrity of their public assistance programs, as persons who require welfare assistance during their first year of residence are likely to become continuing burdens on welfare programs. Appellates also seek to justify the classification as a permissible attempt to discourage indigents from entering a state solely to obtain larger benefits, and to distinguish between new and old residents on the basis of tax contributions that they have made to the community. Certain appellants rely, in addition, on the following administrative and related governmental objectives: facilitating the planning of welfare budgets, providing an objective test of residency, minimizing the opportunity for recipients fraudulently to receive payments from more than one jurisdiction, and encouraging early entry of new residents into the labor force. Connecticut and Pennsylvania also argue that Congress approved the imposition of the 1-year requirement in subsection 402B of the Social Security Act. So right here, we didn't see not one mention of an automobile, car, motor vehicle, license, registration, or anything like that. This is about people traveling from one state to the next for welfare benefits, because there's another state that has better welfare benefits, and they don't want welfare recipients in their state. This falls under the public charge doctrine. I want y'all to look that up. It's called the public charge doctrine. And let's keep going. I didn't see anything about right to travel. Held. Let's see what was held. Number 1, the statutory prohibition of benefits to residents of less than a year creates a classification which denies equal protection of the laws, because the interests allegedly served by the classification either may not constitutionally be promoted by government or are not compelling government interests. You know, they have to demonstrate they have a compelling public interest to do that. What is they said, look, you can put provisions in to make sure they get a job, provisions in to make sure that they don't commit fraud by receiving benefits from 2 different states, and, and something that could compel them or coerce them to go out and get a job. Those are things you can do. So you have to have a compelling public interest to, deny someone a certain right. All right, so since the Constitution guarantees the right of interstate movement, doesn't say travel or anything like that, The purpose of deterring the migration of indigents into a state is impermissible and cannot serve to justify the classification created by the 1-year waiting period. A state may no more try to fence out those indigents who seek higher welfare payments than it may to fence out indigents generally. The classification may not be sustained as an attempt to distinguish between new and old residents on the basis of the contribution that they have made to the community through the payment of taxes, because the Equal Protection Clause prohibits the state from apportioning benefits or services on the basis of the past tax contributions of its citizens. They're trying to say, have you been paying taxes in the state? And they can't do that. They can't, and this classification they keep talking about, this falls under capacity. A person falls into a capacity. A capacity is classified, and that goes into your rights and duties and things of that nature. Number 5, in moving from jurisdiction to jurisdiction, appellees were exercising a constitutional right, and any classification which penalizes the exercise of that right, unless shown to be necessary to promote a compelling government interest, is unconstitutional. Now, once again, this is just them moving from state to state. That's what right to travel is, y'all. Let me show y'all right to travel. Okay, this is a picture of Europe. The people in America who found, the Europeans who founded America, they came from Europe. And so Europe is set up very similar to the United States. Imagine these are states. Okay, you have France, Switzerland, down here even a little bit more, you even have Portugal. Down here in Spain, you got Portugal, Spain, France, Italy, Switzerland, Germany, the Netherlands. I think the Netherlands is right there. You got Belgium in here. You got Austria, Czech Republic, Poland, Hungary, all these different states, Romania, Ukraine, Sweden. This is Europe. Okay, now in Europe, you don't have a right to travel. You need a passport. If I want to go from Portugal to Spain, which I've done, I've been to Lisbon, I've been to Madrid, I've been to Barcelona. When I traveled over there, I need a passport. When I left Spain and went to Egypt and then came back to Greece and then Italy, I needed a passport to go from Greece to Italy and from, of course, from Egypt. I also needed a passport when I went from when I traveled from the Netherlands to Germany, when I traveled from Germany down to France and to Italy and then to France. I went to Switzerland. I went to all these countries and I needed a passport. I didn't have a right to travel, okay? Okay, likewise, this is a picture of the United States. Very similar to Europe. You can see that when they came over here, they set it up the same way. They tried to set up the continent just like Europe was. But over here, they came up with a different idea, something that was very novel. They decided to have a central government and unite. That's why it's called the United States of America. And you don't need a passport to travel. Really, you should be looking at each of the individual states like countries, just like they do in Europe. That's why each of these places have their own individual constitutions. However, in our country, because we have a united country, you can travel wherever you want. It's unlike any other place on earth. This is what makes the United States different than a lot of other places. We have a right to travel between states, whereas in other places they don't. So back, number 5, in moving from jurisdiction to jurisdiction, appellees were exercising a constitutional right, and any classification which penalizes the exercise of that right, unless shown to be necessary to promote a compelling public interest, is unconstitutional. Appellants do not use and have no need to use the 1-year requirement for the administrative and governmental purpose suggested, and under the standard of a compelling state interest, that requirement clearly violates the Equal Protection Clause. Section 402B of the Social Security Act does not render the waiting period requirements constitutional. A, that section on its face does not approve, much less prescribe, a 1-year requirement, and the legislative history reveals that Congress' purpose was to curb hardships resulting from excessive resident requirements, and not to approve or prescribe any waiting period. B, assuming arguendo, for argument's sake, that Congress did approve the use of a one-year waiting period, it is the responsive state legislation and not subsection 402B which infringes constitutional rights. C, if the constitutionality of subsection 402B were at issue, that provision, insofar as it permits the one-year waiting period, would be unconstitutional, as Congress may not authorize the state to violate the Equal Protection Clause. The waiting period requirement in the District of Columbia Code, adopted by Congress as an exercise of federal power, is an unconstitutional discrimination which violates the Due Process Clause of the Fifth Amendment. Once again, there's nothing in here talking about driving an automobile in any capacity, license requirements, registration, because that's not what it's talking about. It's talking about just moving from state to state. These people are trying to go to another state because the other state has better benefits, and they don't want them in their state because they only come in there to leech off the state. Once again, look up the public charge doctrine. Mr. Justice Brennan delivered the opinion of the court. These three appeals were restored to the calendar for re-argument, volume 392, U.S. Reporter, page 920, year 1968. Each is an appeal from a decision of a three-judge district court holding unconstitutional a state or District of Columbia statutory provision which denies welfare assistance to residents of the state or district who have not resided within their jurisdiction for at least 1 year immediately preceding their application for such assistance. We affirm the judgments of the district courts in these three cases. In number 9, the Connecticut Welfare Department invoked subsection 17(2)D of the Connecticut General Statutes to deny the application of appellee Vivian Marie Thompson for assistance under the program for aid to families with dependent children. She was 19 years old. She was a 19-year-old unwed mother of one child and pregnant with her second child when she changed her residence in June of 1966 from Dorchester, Massachusetts to Hartford, Connecticut, to live with her mother, a Hartford resident. She moved to her own apartment in Hartford on August 1966 when her mother was no longer able to support her and her infant son. Because of her pregnancy, she was unable to work or enter a work training program. Her application for AFDC assistance filed in August was denied in November solely on the ground that, as required by subsection 17(2)D, she had not lived in the state for a year before her application was filed. She brought this action in the district court for the District of Connecticut, where a three-judge court, one judge dissenting, declared as subsection 17(2)D unconstitutional. This has nothing to do with driving an automobile or anything. Nothing. Absolutely nothing. And y'all gonna call me an agent for reading this too? So I gotta be an agent. The majority held that the waiting period requirement is unconstitutional because it has a chilling effect on the right to travel. The majority also held, and this is not talking about a car, she had a right to travel. She's just trying to live there. She's just trying to go from state to state. That's what travel means. Right to travel means the ability to go from state to state. Google it right now. Google it what right to travel actually means. Put it in ChatGPT, put it in Google, look it up. The majority also held that the provision was a violation of the Equal Protection Clause of the 14th Amendment because the denial of relief to those residents in the state for less than a year is not based on any permissible purpose, but is solely designed, as Connecticut states, quite frankly, to protect its fiscal by discouraging, protect its fiscal by discouraging its fisc, by discouraging entry of those who come needing relief. We noted probable jurisdiction. In number 33, there are 4 appellees. 3 of them, appellees Harold Brown and LeGrant, applied for and were denied AFDC aid. The 4th, appellee Barley, applied for and was denied benefits under the program for aid to the permanently and totally disabled. The denial in each case was on the ground that the applicant had not resided in the District of Columbia for 1 year immediately preceding the filing of her application as required by subsection 3-203 of the District of Columbia Code. Appellee Minnie Harrell, now deceased, had moved with her 3 children from New York to Washington in September of 1966. She suffered from cancer and moved to be near members of her family who lived in Washington. Appellee Barley, a former resident of the District of Columbia, returned to the district in March 1941 and was committed a month later to St. Elizabeth Hospital as mentally ill. She has remained in that hospital ever since. She was deemed eligible for release in 1965, and a plan was made to transfer her from the hospital to a foster home. The plan depended, however, upon Mrs. Barley obtaining welfare assistance for her support. Her application for assistance under the program for aid to the permanently and totally disabled was denied because her time spent in the hospital did not count in determining compliance with the 1-year requirement. Appellee Brown lived with her mother and 2 of her children, 3 children in the Fort Smith, Arkansas. Her 3rd child was living with Appellee Brown's father in the District of Columbia when her mother moved from South Smith to Oklahoma. Appellee Brown, in February 1966, returned to the District of Columbia, where she had lived as a child. Her application for AFDC assistance was approved insofar as it sought assistance for the child, who had lived in the district with her father, but denied to the extent it sought assistance for the 2 children. Appellee LeGrant moved with her 2 children from South Carolina to the District of Columbia in March 1967, after the death of her mother. She planned to live with a sister and brother in Washington. She was pregnant and in ill health when she applied for and was denied AFDC assistance in July 1967. The several cases were considered for trial, and a 3-judge district court was convened. The court, 1 judge dissenting, held in subsection 3203 unconstitutional. The majority rested its decision on the ground that the 1-year requirement was unconstitutional as a denial of the right to equal protection secured by the Due Process Clause of the Fifth Amendment. We noted probable jurisdiction. In number 34, there are 2 appellees, Smith and Foster, who were denied AFDC aid on the sole ground that they had not been residents of Pennsylvania for a year prior to their applications, as required by subsection 432(6) of the Pennsylvania Welfare Code. Appellee Smith and her 5 children moved in December 1966 from Delaware to Pennsylvania, where her father lived. Her father supported her and her children for several months until he lost his job. Appellee then applied for AFDC assistance and had received 2 checks when the aid was terminated. Appellee Foster, after living in Pennsylvania from 1953 to 1965, had moved with her 4 children to South Carolina to care for her grandfather and an invalid grandmother, and had returned to Pennsylvania in 1967. A 3-judge district court for the Eastern District of Pennsylvania, 1 judge dissenting, declared subsection 432(6) unconstitutional. The majority held that the classification established by the waiting period requirement is without rational basis and without legitimate purpose or function, and therefore a violation of the Equal Protection Clause. The majority noted further that if the purpose of the statute was to erect a barrier against the movement of indigent persons into the state or to effect their prompt departure after they had gotten there, it would be patently improper and its implementation plainly impermissible. We noted probable jurisdiction. There is no dispute that the effect of the waiting period requirement in each case is to create 2 classes of needy resident families, indistinguishable from each other, except that one is composed of residents who have resided a year or more, and the second of residents who have resided less than a year in the jurisdiction. On the basis of this sole difference, the first class is granted and the second class is denied. Welfare aid upon which may depend the ability of the families to obtain the very means to subsist, food, shelter, and other necessities of life. In each case, the district court found that appellees met the test for residents in their jurisdictions, as well as all other eligibility requirements except the requirement of residence for a full year prior to their application. On re-argument, appellee's central contention is that the statutory prohibition of benefits to residents of less than a year creates a classification which constitutes an invidious discrimination, denying them equal protection of the laws. We agree. The interests which appellates assert are promoted by the classification either may not constitutionally be promoted by government or are not compelling governmental interests. Either one, because welfare benefits is going to adhere to the federal government, and they have the Equal Protection Clause, and you don't have a compelling government interest to deny them this. It has nothing to do with getting in a car and traveling somewhere without a license or registration. Primarily, appellants justify the waiting period requirement as a protective device to preserve the fiscal integrity of state public assistance programs. It is asserted that people who require welfare assistance during the first year of residence in a state are likely to become continuing burdens on state welfare programs. Therefore, the argument runs, if such people can be deterred from entering the jurisdiction by denying them welfare benefits during the first year, state programs to assist longtime residents will not be impaired by a substantial influx of indigent newcomers. There is weighty evidence that exclusion from the jurisdiction of the poor who need or may need relief was the specific objective of these provisions. In the Congress, sponsors of federal legislation to eliminate all resident requirements have been consistently opposed by representatives of state and local welfare agencies who have stressed the fears of the state that elimination of the requirements will result in a heavy influx of individuals into states providing the most generous benefits. I say they don't want them in there. Once again, go to public charge doctrine. Read the public charge doctrine. I doubt that Connecticut can and should continue to allow unlimited migration into the state on the basis of offering instant money and permanent income to all who can make their way to the state regardless of their ability to contribute to the economy. All they can make their way to the state don't have nothing to do with how they get there. Just can they get there? Can they travel there? Connecticut General Assembly House Proceedings, February special session. In Pennsylvania, shortly after the enactment of the one-year requirement, the Attorney General issued an opinion construing the one-year requirement strictly because any other conclusion would tend to attract the dependence of other states to our Commonwealth. 1937 through 1938 official opinions of the Attorney General, number 240, page 110. In the District of Columbia case, the constitutionality of the subsection 3-203 was frankly defended in the district court and in this court on the ground that it is designed to protect the jurisdiction from an influx of persons seeking more generous public assistance that might be available elsewhere. We do not doubt that the one-year waiting period device is well suited to discourage the influx of poor families in need of assistance. An indigent who desires to migrate, resettle, find a new job, and start a new life will doubtless hesitate if he knows that he must risk making the move without the possibility of falling back on state welfare assistance during his first year of residence, when his need may be most acute. But the purpose of inhibiting migration by needy persons into the state is constitutionally impermissible. That's right. We know that's what you want, but you can't stop people coming from your state just because they may get on welfare. That's unconstitutional. The court long ago recognized that the nature of our federal union and our constitutional concepts of personal liberty unite to require that all citizens be free to travel throughout the length and breadth of our land uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. That position was early stated by Chief Justice Taney in the passenger cases. Okay, now this is just unreasonable. They have already decided that driver's license as well as registration is not unreasonable. That's not unreasonable. That's not an unreasonable restriction on your right to travel. As a matter of fact, put it in your chat GPT or Google it. For all the great purposes for which the federal government was formed, we are one people with one common country. We are all citizens of the United States, and as members of the same community, must have the right to pass and repass through every part of it without interruption as freely as if in our own states. Remember what I told you earlier, in America, you have the right to travel from state to state. It's not talking about the mode of travel. Traveling in a 6,000-pound piece of steel can kill somebody. That falls under public safety regulation, which is the inherent and police powers of the state, which does not have to be enumerated under the Constitution. That's an implied power of the state. Y'all gonna get somebody killed. I'm gonna show you what's going on YouTube too. We have no occasion to ascribe the source of this right to travel interstate to a particular constitutional provision. Footnote, it suffices that Mr. Justice Stewart said, for the court in the United States versus Guest, the constitutional right to travel from one state to another occupies a position fundamental to the concept of our federal union. It is a right that has been firmly established and repeatedly recognized. The right finds no explicit mention in the Constitution. The reason it has been suggested is that a right so elementary was conceived from the beginning to be a necessary concomitant of the stronger union the Constitution created. In any event, freedom of travel throughout the United States has long been recognized as a basic right under the Constitution. Now, right here, this is not talking about the mode of travel. Okay, and also, you noticed that he said that right to travel is not explicitly mentioned in the Constitution? Thus, the purpose of deterring the immigration of indigents cannot serve a justification for the classification created by the one-year waiting period, since that purpose is constitutionally impermissible. If a law has no other purpose than to chill the assertion of constitutional rights by penalizing those who choose to exercise them, it is patently unconstitutional. United States versus Jackson. Alternatively, appellants argue that even if it is impermissible for a state to attempt to deter the entry of all indigents, the challenge classification may be justified as a permissible state attempt to discourage those indigents who would enter the state solely to obtain larger benefits. We observe first that none of the statutes before us is tailored to serve that objective. Rather, the class of barred newcomers is all-inclusive, lumping the great majority who come to the state for the purpose with those who come for the sole purpose of collecting higher benefits. In actual operation, therefore, the three statutes enact what, in effect, are non-rebuttable presumptions that every applicant for assistance in his first year of residence came to the jurisdiction solely to obtain higher benefits. Nothing whatever in any of these records supplies any basis in fact for such a presumption. More fundamentally, a state may no more try to fence out those indigents who seek higher welfare benefits than it may try to fence out indigents generally. Implicit in any such distinction is the notion that indigents who enter a state with the hope of securing higher welfare benefits are somehow less deserving than indigents who do not take this consideration into account. But we do not perceive why a mother who is seeking to make a new life for herself and her children should be regarded as less deserving because she considers, among other factors, the level of state public assistance. Surely such a mother is no less deserving than a mother who moves into a particular state in order to take advantage of its better educational facilities. Appellants argue further that the challenge classification may be sustained as an attempt to distinguish between new and old residents on the basis of the contribution they have made to the community through the payment of taxes. We have difficulty seeing how long-term residents who qualify for welfare are making a greater present contribution to the state in taxes than indigent residents who have recently arrived. If the argument is based on contributions made in the past by the long-term residents, there is some question as a factual matter whether this argument is applicable in Pennsylvania, where the record suggests that some 40% of those denied public assistance because of the waiting period had lengthy prior residence in the state. But we need not rest on that. Okay, you had even the people who was there longer than a year, you denied them. But we need not rest on the particular facts of these cases. Appellants' reasoning would logically permit the state to bar new residents from schools, parks, and libraries, or deprive them of police and fire protection. Indeed, it would permit the state to apportion all benefits and services according to the past tax contributions of its citizens. The Equal Protection Clause prohibits such an apportionment of state services. We recognize that a state has a valid interest in preserving the fiscal integrity of its programs. It may legitimately attempt to limit its expenditures, whether for public assistance, public education, or any other program. But a state may not accomplish such a purpose by invidious distinctions between classes of its citizens. It could not, for example, reduce expenditures for education by barring indigent children from its schools. Similarly, in the case before us, appellants must do more than show that denying welfare benefits to new residents saves money. The saving of welfare costs cannot justify an otherwise invidious classification. In sum, neither deterrence of indigents from migrating to the state nor limitation of welfare benefits to those regarded as contributing to the state is a constitutionally permissible state objective. Appellates next advance as a justification certain administrative and related governmental objectives allegedly served by the waiting period requirement. They argue that the requirement, number one, facilitates the planning of the welfare budget. Number two, provides an objective test of residency. Number three, minimizes the opportunity for recipients fraudulently to receive payments from more than one jurisdiction. And number four, encourages early entry of new residents into the labor force. At the outset, we reject appellate's argument that the mere showing of a rational relationship between the waiting period and those four admittedly permissible state objectives will suffice to justify the classification. The waiting period provision denies welfare benefits to otherwise eligible applicants solely because they have recently moved into the jurisdiction. But in moving from state to state or to the District of Columbia, appellees were exercising a constitutional right, and any classification which serves to penalize the exercise of that right, unless shown to be necessary to promote a compelling governmental interest, is unconstitutional. I hope y'all are catching the fact that a right can be restricted if there's a government compelling interest. Like, for instance, in the Constitution, it says private property may not be taken without due process of law and just compensation. It doesn't say that it can't be taken. The argument that the waiting period requirement facilitates budget predictability is wholly unfounded. The record in all three cases are utterly devoid of evidence that either the state or the District of Columbia, in fact, uses the one-year requirement as a means to predict the number of people who will require assistance in the budget year. None of the appellates takes a census of new residents or collects any other data that will reveal the number of newcomers in the state less than a year. I'm gonna jump down here. I'm not reading all this because this is all footnotes down here. This is about welfare benefits, man. Let me get down here where in these footnotes. The only place I saw where they kind of even lightly talked about it. It says Congress, pursuant to its commerce power, has enacted a variety of restrictions upon interstate travel. It has taxed air and rail fares and the gasoline needed to power cars and trucks which move interstate. Okay, repealed in part. Many of the federal safety regulations of common carriers which cross state lines burden the right to travel. All right, federal safety regulations, blah, blah, blah. Railroad safety appliances, this is what they're talking about right here. 49 U.S.C. 1421, air safety regulations, that's what they're talking about, railroad and air safety. And Congress has prohibited by criminal statute interstate travel for certain purposes. Although these restrictions operate as a limitation upon free interstate movement of persons, their constitutionality appears well settled. They all constitutional. These restrictions. Got all the case law right here if you want to pull them up. The fact that a liberty cannot be inhibited without due process of law does not mean that it can under no circumstances be inhibited. That should kill it right there. This right here undermines your whole entire argument. Right here, the fact that a liberty cannot be inhibited without due process of law does not mean that it can under no circumstances be inhibited. It can be inhibited. The court's right to travel cases lend little support to the view that congressional action is invalid merely because it burdens the right to travel. Most of our cases fall into two categories: those in which state-imposed restrictions were involved, gave me those, and those concerning congressional decisions to remove impediments to interstate movement. See the United States versus Guest. Since the focus of our inquiry must be whether Congress would exceed permissible bounds by imposing resident requirements, neither group of cases offers controlling principles. None of these cases even apply to the case at hand. In only 3 cases have we been confronted with an assertion that Congress has impermissibly burdened the right to travel. Kent versus Dulles didn't invalidate a burden on the right to travel. However, the restriction was voided on the non-constitutional basis that Congress did not intend to give the Secretary of State power to create the restriction at issue. Zimmel versus Rusk, on the other hand, sustained a flat prohibition of travel to certain designated areas and rejected an attack that Congress could not constitutionally impose the restriction. Neither one of those supports your argument. In the only case in which this court invalidated on a constitutional basis a congressionally imposed restriction, Apather also involved a flat prohibition, but in combination with a calm claim that the congressional restriction compelled a potential traveler to choose between his right to travel and his First Amendment right of freedom of association. These cases aren't, listen, man, none of these cases is talking about license and registration. Give me something else. And before I go, I just want you to get on the internet and put in sovereign citizen right to travel fails. And I want you to look at all of these videos they have taken of people who've gotten pulled over, some locked up, some cars towed. I mean, there's probably a couple of thousand on the internet by now. And all these people doing right to travel, none of them have been successful. Tons and tons and tons. And I mean, it's gotten so bad, the police officers, they so trained now, they ready for all the arguments you make for right to travel, they ready for them now. They've been so thoroughly trained. But private traveler, all this stuff, show me the case, judge is not playing games. 5-time sovereign citizen learned a hard lesson on body cam. American dream can thrive anywhere. All it takes is freedom. No, that's not it. What is it? Turtle Island update. More sovereign citizen travel to fail. Bonus. Sovereign citizen's greatest fail ever. Sovereign citizens laughed at in the court by a judge. Insane Florida judge destroys right to travel. Sovereign citizen in courtroom showdown. Sovereign citizen right to travel fail and more. Sovereign citizen right to travel failed in Florida. Sovereign citizen right to travel fail. Sovereign citizen couple right to travel fail and post office fail. Sovereign citizen right to travel fail in Oregon. Sovereign citizen right to travel fail, towed and arrested. Sovereign citizen right to travel fail in Georgia. Sovereign citizen watch more frauditors and right to travel fails. Sovereign citizen and his Facebook group right to travel fail. Sovereign citizen right to travel fail, 2 and more. You can keep going and 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 going.